Jay,
Yes.
I am going to need to legally call it you Spring
Yes.
when I do the things, but I will call you Jay otherwise, okay?
Yes.
We will go on the record in the matter 26 CF 72, State of Wisconsin versus Spring Staples, otherwise known as Jay. The state appears through District Attorney Kevin Schmidt in person. We also have 13 CM 347. Jay appears in person with counsel Amber Sherwood, making a special appearance on Jay's behalf. We're set today in this matter for a return on warrant initial appearance, as well as an initial appearance on another matter. Ms. Sherwood, were you able to go over the criminal complaint with Jay?
I was able to go over both and the maximum possible penalties. We waive further reading on both, Your Honor.
All right. Not guilty plea as to the 13 case?
Yes, Your Honor. We would like a prelim for the felony. We waive time limits. Spring does not qualify for the public defender.
All right. Is there an offer prelim that could be made? It's a possession of THC second with a disorderly from 2013. We have $500 cash posted.
If they plead to THC, we'll do cost, dismiss everything else
All right. So
as a misdemeanor.
Something that you can think about. You do not qualify for the public defender, so you can retain your own private attorney.
Here is a reality check many viewers don't realize. There is a justice gap, where you make too much for a public defender, but not enough for a private one. It often leaves defendants forced to represent themselves or take whatever deal is offered first.
You wish to accept the agreement, the offer?
How long?
Yes. Do you need a week? Do you want 2 weeks? Do you want 3 weeks?
Honestly, Your Honor, I don't know. Maybe give me maybe 2 weeks.
I can give you more time too if you want.
Or
I just want to make sure that you've had enough time to be able to talk to an attorney if you want, or decide if you want an attorney, or to think about the offer, talk to your friends, talk to your family, all of those things.
yes. So I'm gonna definitely need more time and talk to my family about it.
I can do July 7th at 10. Okay?
Yes.
So you can come up here and get your notice, and then you are free to leave, okay?
Okay.
Are you still at, I can't say it, your road?
As you go on with, yes.
Okay, and telephone ends in 2287?
No.
Can I get an updated, please?
470-955.
May I send you text message notifications if we need to? Okay, thank you. All right, get your notice and you're free to leave. Bronson Benjamin. None of this.
To determine that she is eligible for public defender representation. There are other people involved in this case. I'm not sure at this time if it would be a conflict. I think at this point I would be asking for an adjourned initial date to allow us to figure that out.
Well, Ms. Shute, did you read that criminal complaint? Yes. Do you want to move forward and keep the matter moving? Yes. And so you can read, right? You understand the English language? Yes. And you read that charge? Yes. And the maximum penalties? Yes. And did you read the allegations in that probable cause statement? And I'm not going to have you say they're true to your best of your knowledge or not true, but you read that? Yes. And so you don't need me to read anything out loud to you today? No. And enter a not guilty plea? Yes. Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Still on Sandpoint Road? Yes. Telephone ends in 9791? Yes. Is this something that an offer could be presented?
The offer on this is to plead to the offense for costs.
Okay, so plead to the charge, no recommendation of jail, just for court costs and mandatory costs. Okay. So that's what it is. I'm going to give you time to think about it and to get an attorney, and 1 o'clock. Okay. Okay. I just want to make sure we do this all right and you understand and you have all those things. Okay. So if you would like to.
Failing to appear is the fastest way to turn a minor charge into a major headache. Even if you're actually sick, the court's default assumption is that you're running, which is why the judge is pressing for proof.
You just go have a seat or go outside and talk, then we'll. Misty Kirk. I don't think she's here, Your Honor. Okay, Devin Coatsey.
He's not here, but we can go on the record.
He's not going to be here? We will go on the record in the matter 26 CF 40, State of Wisconsin versus Devin Coatsey. The state appears through District Attorney Kevin Schmidt in person. Mr. Coatsey fails to appear. We have Emma Hanu, his counsel, in person. We're set today in this matter for an initial appearance. Any news or information you can provide to me, or do you wish to stand mute?
Yes, Your Honor, I do have information that I can share. Mr. Cote contacted me at about 11 o'clock this morning and advised that he intended to appear and was going to appear in person, but that he is very sick and has been profusely vomiting all day. I did file a request to appear remotely prior to that, but with the time limit, the timing, I don't think the court took action on it. That being said, I think Mr. Cote is currently down and out due to illness. That's all I got.
Going to the doctor.
That is what I am trying to determine what he's up to. I did advise that if the court did not issue a warrant, or even if they do issue a warrant, that he should get a doctor's note.
This is the second time that it will be reset. This will be his second and final time to be reset. June 15th, 26 CM 64, 26 TR 307 and 308, State of Wisconsin versus Roger Peterson. The state appears through District Attorney Kevin Schmidt in person. Mr. Peterson appears in person with counsel Emma Hanu, making a special appearance on his behalf here today. We're set for an initial appearance. Ms. Hanu, were you able to go over the criminal complaint with Mr. Peterson?
I was not. Attorney Sherwood was. He's advised he understands the sole count of misdemeanor theft and wishes to enter a not guilty plea.
Not guilty plea will be entered on his behalf. He is entitled to a jury trial, would be entitled to a speedy trial should he request one. Is this a case that's going to involve restitution?
We don't know yet.
I would.
So, an offer can.
It is surprisingly common for defense attorneys to be surprised by extra charges in open court. It shows how chaotic the court's docket system can be, where traffic tickets and criminal charges don't always get filed in the same digital folder.
Not be presented.
The offer that was intended to be presented is pleading to the offense for 1 year probation.
Leading to the theft, DRI, the rest.
There is one count. On
Yeah,
the
there's just one
complaint.
charge.
We have two. I have possession of open intoxicants and operating while suspended.
Oh, I don't know about any tickets. Let me see.
Making your payments?
What?
Are you still making your payments?
Yes,
'Cause I haven't checked in a while, to be honest.
I just made another one today.
Thank you. You're doing what you need to do. All right, so Mr. Peterson, you can either retain your own attorney. Pretty sure you don't have the funds to do that. Or you can apply for a court-appointed attorney, but that's going to cost you $100 an hour, okay? You can represent yourself. Those are your options and things you can do. The offer is to plead to the theft charge, the misdemeanor charge, for costs only. And quite honestly, it would just tack on to all the other stuff you owe.
That was not the offer. It was 1 year probation.
Oh, sorry, not costs only. I meant 1 year probation. Sorry, for 1 year of probation. And for court costs, obviously, but so that's the offer. I'm going to give you time to think about if you want an attorney, you want to represent yourself, you want to accept the offer, all those things. I'm going to give you it and take care of it that day.
Okay,
Okay?
so I'm still, I have that one other charge in that
Other charge.
well, operating after suspended and open intoxicants.
Those would go away too.
Oh, okay,
Okay?
both of them.
Yeah, both of them would be dismissed.
Okay,
All right, so it was just plead to the theft for 1 year probation recommendation. You can argue to the court for anything else, anything you want to argue for. And those two matters, those other two, the operating while suspended and the possession of intoxicants in a motor vehicle, are going to be dismissed and read in, okay?
Okay.
So think about it. If you wish to accept it on the 7th, I will gladly take care of it that day,
Okay.
okay? All right, you can come get your notice. It does say we need fingerprints too. I need fingerprints with every file. So you're gonna need to come up here and get the form for fingerprints as well. Go outside around the back to the jail's intake and provide fingerprints, and then you're free.
The judge is discussing $4,000 in cash bond. Forfeiture means the state keeps that money because the defendant missed court. Staying the forfeiture is a massive financial break, usually only granted if there's a legitimate mental health or medical crisis.
Free to leave, okay? And then, you know, at that July 7th, we'll probably talk about, I'll add, can you add a financial? No, I'll talk to Amy. We'll add a financial hearing too, just so I can get updated on where you are, see if there's anything we can waive, see if you can do some community service, those kinds of things. Okay?
Okay. Thank you.
I'll just make note. All right, we'll go on. At the last hearing, $4,000 was posted and the court did order that the cash be forfeited. However, I did stay on any forfeiture. Why was he not here?
Your Honor, I think Mr. Sanders was having some mental health issues. I know he checked himself into counseling at the VA center within about 2 weeks of his missed court date. I don't know the circumstances of how he got arrested. I didn't actually expect that was going to be an issue today. I just knew it was set for today, and I thought we were just doing a status.
Okay. Mr. Sanders, you don't have to get into too much of it or any of the things, but is what your attorney's telling me accurate?
I believe so, yes.
And so did you purposely miss court?
No.
Judge, I'm going to advise him not to answer that question.
Said no.
I didn't know what the answer was going to be, but I've been in trouble with that on the record before. I'm just going to advise him against answering that.
Well, he said no. Can I take his no?
Yes, Judge.
All right. Okay, so you didn't purposely do it. You were experiencing a little ups and downs at that time.
Yes, Your Honor.
And you're going to be coming back to court
Yes, Your Honor.
every time I say to be here,
Yes, Your Honor, I will.
and you're going to stay in contact with your attorney.
You bet. Yes, Your Honor.
I'm not going to forfeit that $4,000 because that's a lot of money.
I'd have to go back and check again.
I'm going to guess. Mr. Sanders, do you have family,
No,
children, anything like that?
no.
What kind of affairs do you need to get in order? Do you have a lot of things that you need to get and set in place?
Yes, I do, Your Honor.
And do you own a home?
Yes,
And so you need somebody to maybe stay in your home and watch your home?
yes, Your Honor,
Yeah.
that's correct.
Do you have pets?
Yes, I do.
And so you need to make sure that they're taken care of as well?
Yes, Your Honor.
Okay, and I'm going to guess you're not working right now.
I'm retired.
Okay, so you're retired and all of those things. So you just need some time to be able to get everything set up. So you feel comfortable, but you are accepting the state's offer of pleading to the charge and understanding that there is a mandatory prison sentence? Okay, and so I'm gonna give you some time, a few months, to be able to get your affairs in order. This is not a terribly old case, and I do understand the commitment that it and the courage that it takes to understand that it is
A PSI, or pre-sentence investigation, is a deep dive into a defendant's life. By skipping it and offering background info themselves, the lawyers are trying to keep the sentencing narrative under their control, rather than leaving it to a probation officer's report.
prison sentence. So how would early August, is that enough time?
For me, yes, Your Honor.
Mr. Chapman, I could do, how about August 24th? I can do 10 a.m.
That works for me.
All right, August 24th at 10 a.m. So now you have your deadline, you know your things that you need to get all lined up and everything. Stay in contact with your attorney. Okay?
Yes.
And if you don't come to that hearing and it's a ways out, and I know you're gonna have to remember, but a warrant would be issued and I probably won't be so lenient the next time, okay?
I understand, Your Honor.
All right, so you can come up here and get your notice. just a normal half hour?
I don't think either of us are going to be asking for a PSI. Do you anticipate the court wanting a PSI?
My guess is for the most part, it's OWIs only. So I'm just going to hope that either you or Mr. Sanders will give me a little background about his history. If he's a veteran, if he, his family connections, those kinds of things that you would typically find in a PSI, anything that you think I need
Yes,
to
Judge.
understand.
I'll be ready for a sentencing then.
Okay, so we'll do it all, bam, wham, done, okay?
Yes, Judge.
So a half hour should be enough for
I'd say an hour.
hour, okay. Sir? Okay, you can come get your notice and you're free to go.
Thank you, Your Honor.